Hey there, Legal Tea listeners. This is your host, Jenny Roselle. Today we're on the estate planning of the rich and famous topic, and for today's episode, we're going to be diving into what is going on following the too soon and tragic passing of Anne Heche. Now, if you're like me and struggle connecting celebrities' faces and names, Anne Heche is most known. She's a kind of short, blonde, often pixie cut haircut. She was most known for her acting in movies like 6 Days, 7 Nights with Harrison Ford and the movie Psycho with Vince Vaughn. And everyone remembers and knows that infamous bloody shower scene in the movie Psycho, right? Another thing she's known for is her past relationship with Ellen DeGeneres, which lasted for many years, I think actually over a decade. According to her Wikipedia, her and Ellen were described as the, quote, first gay super couple. So clearly, between doing movies with Harrison Ford and Vince Vaughn and being in a relationship with Ellen DeGeneres, I mean, that's like big stuff, right? Well, I'd argue she's most known for those movies and her affiliation with Ellen, but she was also in a variety of other films and movies, and she even published her own memoir, which dove into some very personal experiences she went through. Needless to say, she's very well known, very successful, and gone too soon. On August 5th, 2022, Anne was in a car accident. Her car ultimately crashed into a house at a very high rate of speed. This was after she was involved in some other somewhat smaller incidents right before she crashed into the house. According to Wikipedia, the vehicle entered the house, broke through the wall, and went 30 feet inside the house. Thankfully, the individual was home and inside the house, but was not seriously harmed. Consequently, the vehicle caught on fire, though, and Anne was trapped inside the vehicle. After the accident, the Los Angeles Police Department determined through a blood analysis that there was presence of cocaine and narcotics, including fentanyl, in her system. Sadly, Anne ultimately succumbed to her injuries, and after a handful of days on life support, she passed away on August 11th, 2022, at the age of 53 years old. At her passing, Anne left 2 children, Homer and Atlas. Homer was Anne's child with her ex-husband, Coley LaFoon, who, according to People magazine, was who Anne was married to from 2001 to 2009. Atlas was Anne's child with her former partner, James Tupper. According to People magazine, Anne and James split in 2018 after 10 years together. After her relationship with James ended, she was not really linked to anyone else, relationship-wise. According to a Rolling Stone piece by Nancy Dillon, approximately 3 weeks following Anne's passing, specifically on August 31st, 2022, Anne's oldest child, Homer, filed with the Los Angeles County Probate Court to open an estate for his mother. It was filed as an intestate case, which, as we know here on Legal Tea, means that she supposedly passed away without a last will and testament. In his filing, Homer requested to be appointed as the estate's administrator, so think executor. That just must be what California calls an executor. And in addition to that request, the petition also requested that a third party be appointed as the guardian ad litem for Anne's youngest child, Atlas, who is legally considered a minor. I think he's in his early teenage years, maybe 13 or so. I think I'm going to pause for 1 second and explain what that term of art means, guardian ad litem. I want to because actually in the Rolling Stone article, Homer's attorney mentioned that people thought he was seeking to become Atlas's guardian, which was not the case. I'm sure these rumors started because many don't understand what a guardian ad litem is. So let's talk about it. A guardian, not a guardian litem, a guardian is someone who is court appointed to be another person's decision maker, which is different than what a guardian ad litem is. A guardian ad litem is someone that is still appointed by the court, but they don't become the person's decision maker. Instead, they are the advocate for the person to make sure whatever decisions that get made on behalf of the person are like on the up and up and are good for that person. So Homer, in his petition, was not asking to become Atlas's guardian. He was asking for someone to be appointed by the court to look out for Atlas's interest in the estate. About 2 weeks following Homer's filing, James Tupper, which if you're keeping track is Atlas's father, James filed a petition and opposed many of Homer's requests in Homer's original petition and argued that Anne had actually sent James an email in 2011 explaining what her wishes were in the event that she passed away. So James's argument was that it should be considered to be like a quasi last will and testament. Furthermore, James argued that Homer should not be appointed as the estate's executor because Homer, quote, lacks the maturity required of an administrator, and that Homer's lack of personal assets and income would render him unable to post the required bond, end quote. Because of this, James argued he should be considered to act as the estate's executor instead of Homer, and that he'd also consider hiring a professional fiduciary to manage Anne's estate. You know, I recall when I started hearing some drama happening with Anne's estate, I knew there was some stuff going down, and I just really kept seeing kind of headline after headline, Homer this, James this. Well, now that I've dove into this topic, that gut feeling was so accurate. So the drama continues. According to the Rolling Stone article, in James's petition, he shared that Homer and Atlas were supposed to attend a grief counseling session after their mother's passing. Well, James explained that Homer failed to show for it and actually even skipped a planned dinner that was supposed to occur between the three of them, leaving James, and Atlas waiting an hour and a half for him to show. James shared, quote, "This is particularly upsetting given that Atlas is 13 years old, was with his mother on the day of her death, and he has reached out to Homer repeatedly. In fact, since their mother's death, Homer has not seen his brother nor had any contact with him. In light of this behavior, Homer will not act in his brother's best interest," end quote. So yeah, needless to say, there are a lot of words and accusations getting thrown around between Homer and James. At that point, legally speaking, things kind of hit pause until early mid-October of this year, 2022, which was when the next status conference hearing would be specifically on October 11th, 2022. According to a Los Angeles Times article by Gregory Yee, at that hearing, quite the show went down, to say the least. The main topic of the hearing was who is going to be the estate's administrator. Is it going to be Homer? Is it going to be James? Is it going to be someone else? Well, believe it or not, the judge sided with 20-year-old Homer. And in his remarks, the judge said, quote, "As earnest as Mr. Tupper's," that's James, "testimony was on the importance of preserving the relationship between the siblings, and how the appointment of Mr. Laffoon," that's Homer, "as administrator might affect that relationship, the court is not aware of any authority to support the proposition that appointment of the present petitioner, Homer, should be denied in favor of someone else having a lower priority based on that consideration," end quote. James's attorney immediately questioned Homer's age, his maturity, his ability to manage the estate, to which the judge responded, quote, He's not qualified on what basis? In California, you can be illiterate and be an administrator, end quote. So at the conclusion of the hearing, the judge set a follow-up status conference hearing for November 30th, 2022, and extended Homer's temporary control over his mother's estate to December 14th, 2022. According to a Page 6 article by Bernie Zilio, Homer, as the current estate administrator, now has access to obtaining more information related to Anne's assets and values of those assets. In a recently filed document with the court, Homer shared that Anne's estate is approximately valued at $400,000, and that in addition to that amount, he also expects that from royalties and residuals, an annual income of around $400,000. That seems pretty low, huh? For at least a celebrity. Homer revealed a little more information about what the $400,000 estate value contained. He shared that she resided in an apartment, so nothing house-related was inside this estate value. The estate really involved some bank accounts, some tangible personal property, the income, the royalties, an LLC interest related to her podcast, and future profits related to her second memoir that is set to be released in 2023. So since her passing in August of 2022, and now, as we sit here just a couple months later in 2022, so much has occurred, right? So much has occurred in these last couple months, so much drama. And time will only tell if James continues to push any more issues. I did notice that the court left Homer as, quote, temporary administrator of the estate. Maybe the judge is using this time to test Homer and see if he can appropriately serve in this role. I'd assume that any misstep by Homer, James will be at the ready to call him out and point the finger like, I told you, court, he shouldn't be in this role. Or maybe Homer will do a fine and dandy job and James will just continue to sit on the sideline. Like I said, time will tell. As we start to wrap up this episode, a couple things to learn. First, I think it's pretty clear that James' assertion that Anne's email to him back in 2011, for that to be considered a will, it's just obviously not enough. So, as I say time and time again on here, if there's anything that you don't want to screw up, estate planning has got to be near the top. Whether she sent an email to James or not, I don't even think that matters. An email to someone is not going to count as a will, my friends, in any stretch of the imagination. Whether you have very modest savings or not, even a very basic estate plan is always needed, and you'll never convince me otherwise. Even if it doesn't govern many assets, merely appointing, say, XYZ person to serve as the one in charge, the executor, that's vital. I actually worked on a case where after mom died, there wasn't much at all. I think it was like a $50,000 house. But the kids started fighting, not over the money, but who should be in charge. And guess who got a big old chunk of that $50,000? The lawyers. Okay, let's wrap this episode up. Next week, we're back to a cautionary tale episode where we talk about real-life clients, real-life cases, and facts that I or my office have worked on. And during next week's episode, we're going to be talking about a client that had appointed a corporate fiduciary, specifically a national bank, as a backup trustee in their estate plan. Well, the first person died as the first backup trustee, that person had already died. And then the bank, who was the second backup trustee, basically said that the estate was too small and they didn't want to serve in that role. It was a mess, to say the least, and we had to end up getting the court involved to get a new trustee appointed, all because the estate was too small for this national bank. So next week's episode will be a great example of sort of, the more you know type of thing, especially if you do have an estate plan and have a bank appointed somewhere in your documents, which used to be a really common thing to do. Alrighty, I'm out, Legal Tea listeners, so take care and be well, and talk to you next Tuesday.